नमस्कार दोस्तों, we are going to discuss landmark judgments in Indian Constitution. Several times, our justices they have told Indian Constitution is a living document. What do you mean by living document? Now, almost 75 years since independence in 1947, right? We have achieved many things. Constitution has gone to a lot of changes, right? So even in this area also today we we say living document. Why? Because constitution has gone to many adaptations. Even India is the largest democratic country, so we will discuss many of the landmark judgments that impacted Indian constitution. First thing, what do you mean by great judgment? What is mean by landmark judgment? According to this Peter Ronald D'Souza, he's a professor at study of developing society in Delhi. Great judgment is basically, suppose say we have constitutional values. It basically studies wherever some deviation is there. Suppose say Article 14, equality before law, equal protection of the law. So if suppose deviation is there, it just correct to that. When it comes to landmark judgment, it completely overhauls the constitution. It interprets our founding forefathers, Dr. B.R. Ambedkar, and several other people, those who are involved with the constitution making. So they might have thought something while making the constitution. So Supreme Court does the same, right? They will make the certain decisions such as constitution is supreme, and then they will bring certain judgments that sometimes state government cannot take away provisions of the constitution. They should maintain the integrity of the constitution. These kind of judgments they are called landmark judgment because they will decide right, the necessity of the constitution, and then necessity of the our judgment also. First case here, A.K. Gopalan versus State of Madras. This case came under 1950. This article discussed about Article 32. Person who is whose fundamental rights gone under Article 13, 19, 21, 22, they can go to court under Article 32, even Article 226 of the state High Court. Supreme Court in this case told that Article 22. What is Article 22? This is detainment. So state can detain even if these articles, fundamental rights are violated. State has that right. Basically, this judgment told that state has ultimate control over the citizens, over their fundamental rights. The next, Maneka Gandhi versus Union of India. This case, even after 28 years, they revisited this Eka Gopalan case. Earlier, they told state has control over detaining people under over the fundamental rights. So now, this is a landmark judgment. Supreme Court told that just state by establishing a law, it doesn't mean they can control the personal liberty. The person, right? Maneka Gandhi, she wanted to go abroad, and then state government restricted that time. Then Supreme Court told that see, going abroad is a right to life. They can go right to liberty. They can go anywhere they want. It is under Article 21. So this is landmark judgment. So even Supreme Court told that law made by state government should be fair, justice, and reasonable. It shouldn't be oppressive, even arbitrary. You cannot make some law for some people. Suppose say I am from BJP, one person is there from Congress, so he's going for outside. Suppose say, or like I'm from Congress, someone from BJP, right? He's going. Suppose say Congress is ruling, BJP is in opposition. Suppose say BJP is going outside, then we cannot put arbitrarily case on them. So it should qualify, like fundamental rights also. That's what this is landmark judgment. Remember, Maneka Gandhi versus Union of India. Even Shankari Prasad versus Union of India case also, they dealt first time with these fundamental rights. Supreme Court told that power conferred to Parliament under Article 368. What is Article 368? Amendment power, amending the Constitution, right? Fundamental rights come under Part 3 of the Indian Constitution. Supreme Court told law must be taken to make rules, like ordinary legislative power, not amendment in the constitution, right? So basically, they have reiterated they can amend the fundamental right under Article 368, and then it can falls under Article 13 also. Article 13 deals with law basically, right? Even they have told in Sajjan Singh versus State of Rajasthan in 1965. Then issue regarding power of the parliament to amend this fundamental rights again re-examined in Golaknath versus State of Punjab in 1967. This case examined the amendment power of the law within the meaning of this Article 13 of the Constitution of India, whether fundamental rights can be amended by the parliament. This case overruled Sajjan Singh by 6 to 5 majority in Supreme Court, and then they held that Article 368 is a law within the meaning of the Article 13(2), right? It further ruled legislature does not enjoy power to amend Part 3 of the Constitution to take away or abridge these fundamental rights. So, state or parliament cannot take away these fundamental rights. Even this is a very important case. Keswananda Bharati Sripada Galavaguru versus State of Kerala. Basically, it is called Keswananda Bharati case. Very important. It is one of the landmark judgment celebrated in Indian constitutional law. With a 7-6 majority, bench told that whatever they proposed in Golaknath versus State of Punjab, law constitutional amendment is not law, right? And the meaning of the Article 13, and although no part of the Constitution, including this Article Part 3 of the Constitution, compromising of these fundamental rights, was beyond the Parliament amending power. Basic structure of the Constitution is dictated here. Basically, what they told is earlier government by bringing the law, they can make amendments to fundamental rights. You cannot, their fundamental rights are not guaranteed. Now, Supreme Court brought new word called basic structure. So fundamental rights fall within the basic rights. So that means Parliament cannot make law and they cannot take away the fundamental rights. So this basic structure doctrine came. Supreme Court told what is a basic structure? They told we will issue guidelines from time to time and the case to case. Whenever Supreme Court make a law and they abrogate the fundamental rights, then Supreme Court intervenes and then they will decide whether it is a basic structure or not. Remember, this case is very important. Case one on the Bharati. Next, Indira Nehru Gandhi versus Raj Naren case in 1975. 39th constitutional amendment, it came in 1975. It told, like election of the president, vice president, prime minister, even speaker of Lok Sabha, they cannot be discussed in even challenged in the Supreme Court, High Court. Then Supreme Court struck down this case, telling that judicial scrutiny is a basic structure. Judicial Judiciary can take any of the cases, they can take down like whether it is meeting the constitutional values or not. So they brought this basic structure of the constitution under Article 329A. They struck down because it is violating the constitution. Remember, Indira Nehru Gandhi. Even Minerva Mills case in 1980. 42nd Constitutional Amendment Act. You might be knowing what is 42nd Constitutional Amendment Act. This is very important. This is called mini constitution also. This gave unlimited powers. Unlimited power to to parliament, even challenge the ground, like all these things were challenged in a basic structure of the constitution. Court struck down all these things under Article 368. Even court told that Article 368 itself is a basic structure. You cannot make the amendments to the constitution. This judgment made it clear that basic structure is very important. Supreme Court will honor it, and then Constitution is supreme, not constitution. Remember here, this is very important. Who will protect the constitution? Not parliament. It is the courts, Supreme Court, High Courts, and all. They works on the constitutional values. They also told that government is not supreme. Constitution is supreme. This is very important word. Government constitution is supreme. So this is a landmark judgment they gave in Minerva Mills case also. There is a ninth schedule case. Ninth schedule. What happened was, to prevent them from judicial scrutiny, many of the clauses were put up under this ninth schedule. So that means judiciary cannot discuss this thing. Then after this April 24, 1973, where they delivered this Keswananda Bharti case, Supreme Court told whatever thing you have put under ninth schedule after April 24, 1973, all the things will be taken up and discussed by case, and if it violates the basic structure, then it will be struck and will be notified as null and void. The supremacy of the constitution is very important, and even they made that a judicial review is very important. Even they told judicial review is a basic structure of the constitution. Remember this case, IR Coelho case. Then one more landmark judgment came in the public interest litigation. What do you mean by public interest litigation? Suppose say some parties are there, some people are there, right? They are faced by a lot of issues and right entire community. Suppose say one tribal community is there in tribal area. One industry has been established, a lot of effluents have been released in that area. People dies, but tribal people they don't have any much knowledge and they will reside in forest areas. They don't have much knowledge also. They don't know where to go, whom to seek. Even political parties, politicians also, they sit in far reaching area. Even if they complain also, politicians whether they will take up or not, it is not known. So that landmark judgment came, this public interest litigation, it came in 1976 under Mumbai Kamgar Sabha Bombay case. This is very important, you can consider. This is foundation of landmark judgment. Justice VR Krishna Iyer, he told that there are several rural poor are there, urban lay people are there, even weaker societal segment from whom there is always terror to them. They are terror from they don't have access to law, or because there are a lot of shortcomings, they cannot afford the legal services. So this should be the case for anyone can file case on their behalf. This became landmark judgment, Mumbai Kamgar Sabha versus Bombay. Next article is about this Sunil Batra, Delhi administration and others. This is also landmark judgment even in prison reforms. Suppose say someone caught up by the police because he did some murder. It doesn't mean like he will be imprisoned and he will be put up in jail. It doesn't mean his right to life guaranteed under Article 21 of the Indian Constitution that can be hampered. Supreme Court told that right to life, personal liberty, he can exercise, but it is limited in certain extent because he is incarcerated. No person until and unless proven guilty, he's innocent. That's what court follows the rule. So this is landmark judgment. It even they even told that court state government should improve the conditions of the jail inmates. They should make they improve their conditions. There should be a healthy mediation should happen between the people and the rule of law. Just because they made some law, so this, what is the meaning of the prisons? If you put people in the prisons, you are saving from the society. In one way it is okay, yeah, good, but prisons are to reform the people. But what is happening is overcrowding is happening. They don't seek justice. Many things are happening, even lockup deaths are happening, and then they don't have judicial reach. They cannot afford money. Many of the people are poor people are there. Sometimes they are falliously put inside because of they just accept the case for financial needs. There are many such cases are there. So this became landmark judgment for prison reforms. Sunil Batra versus Delhi administration. Even Bandhua Mukti Morcha versus Union of India. This case, bonded labor. This raised about the bonded labor. Bonded labor was practiced in olden days. Suppose say one person is there from family, his son is there, right? Father and son. So what he does, father, he might have taken some 10,000 rupees loan from well-known, upper caste people in India. Then he cannot repay it. Now what he needs to do, he need to put his child there, and then he does all sort of works there. And then after that, 1 year they will completely, exploit him for 2 3 years just for 10,000. Then they will leave it. Then this became a landmark judgment to avoid this bonded labor. Because of this poverty, disability, and a socially economic disadvantaged position, any member can file a case, move to court under Article 32. What is Article 32? It grants about the writs. They can, whenever the fundamental rights are imprisoned, they can go to writs. 32 under Supreme Court, 226 under High Courts. What are the writs? Habeas corpus, mandamus, certiorari, quo warranto, and prohibition. These are all the five things. You can go to court, you can seek, you can redress your judicial position when your fundamental rights are positioned. Suppose the poor people they cannot afford all these things. On behalf of them, anyone can go and file a complaint in High Court or Supreme Court. This is a landmark judgment. Bandhua Mukti Morcha versus Union of India. Article 21, right to die with dignity. This is passive euthanasia case. Very sad to say, one woman is there, was there in Mumbai. I don't remember exactly, but right, she was raped, she was molested, and then she was, like attacked, and she went into persistent vegetative state, PVS. What do you mean by vegetative state? Basically, person is living but dead. Basically, she cannot do all her work. She will be, like chronic healthness issues all will be there, and then she cannot walk also. If you see that case study, it is very, like even heartwarming also. In this case, Supreme Court told that it gave, persons to live or die with dignity, and it gave regarding, like guidelines regarding passive euthanasia. It told that people, suppose say now she is facing a lot of issue, sometimes we may feel that it's better to die than live in pain. So it is very even important thing, she is sustained for 36 years, such a dedication and hard work, even, like mental resilience, you can understand, she fought with her life, just on the ICU intensive care unit. Many of the doctors felt sorry for her also. Even you can read that thing, even you can write in ethics also, right? Very sad to know these things are happening in India these days. No respect towards women. These things should be avoided. We need to teach people with value based education, right? So basically, whenever a person wants to die in such a circumstances, their parents, their husband or spouses, husband or wife, even close relatives, if no one is there, anyone who is a friend to them, even body of person who is next to friend, or any doctors attending the patient, they can take the subjective approval from High Court, Supreme Court, and then they can make right to die with dignity. This case is known as, like passive euthanasia case. You can quote anywhere, even ethics also. Even Common Cause versus Union of India, Apex Court told that, like right to life and dignity ensured under Article 21 of the Constitution. It encompasses many other things, like dignity, right to live with dignity, and the smothering process, dying with terminally ill patient. So this is one of the landmark judgment. The right to die with dignity, transgender persons, NALSA Act. This is very important. National Legal Service Authority. It gave, uh, third, Supreme Court told that you cannot make them, like it identified them as a third gender person, transgender people as third gender. Then they told they have right to life, equality before law, equal protection of law, right to life and space, even right to life also. All these things, they have personal autonomy and self-determination. So Supreme Court told identify them as a third gender and then make the laws. Even it directed center and state government to take steps to treat them, socially, educationally backward and make them reservation in certain cases. This is important case. Remember, transgender persons versus National Legal Service Authority versus Union of India. Even right to privacy, Puttaswamy versus Union of India, Puttaswamy cases. In this case, basically Aadhaar Act case also it is called right to privacy. Right to privacy, it became fundamental right under Article 21. If your privacy is breached, so you can go to Supreme Court or High Court under Article 32 to 26, writ, right? Basically writs. You can put a case file directly and then you can directly go to Supreme Court or High Court. This is called right to live with dignity case, Puttaswamy versus Union of India. This case is also very, very important. Decriminalizing homosexuality. Earlier, homosexuality was criminalized under Indian Penal Code IPC 377. Supreme Court told that this IPC 377, it is Victorian era where Britishers were ruling at that time. It was based on their morality. Now we have to give way for constitutional morality. It has been almost several years since Constitution came into being. Our founding fathers taught many things to us. So Constitution told we have to give way to constitution morality, and this, criminalizing homosexuality violates Article 14, 15, 19, 21 also, right? This historical judgment unanimously, even five judges, they unanimously gave, decision. They decriminalize homosexuality under, Section 377 of the Indian Penal Code. This is very important case from gender justice point of view. Shah Bano case in 1985. This is milestone journey of the gender justice. Petitioner Shabano Dixi prayed for grant of maintenance under Section 125 of the Criminal Procedure Code. The Constitution bench told, see, this Section 125 of the Criminal Procedure Code, see, this is truly secular in character. This goes about the religious value. So this should be given, right? He should be given grant of maintenance under Section 125 of the Criminal Procedure Code. So this is one landmark judgment when it comes to gender justice. Even preventing sexual harassment at workplace, this is called Vishaka guidelines. Even Vishaka versus state of Rajasthan. Bhanwari Devi, she is a social worker from Rajasthan. She was brutally gang raped by 5 men, for preventing the child marriage, basically. Trial court, acquitted all 5 accused. And then Vishaka is a group of women's education research center. They took up the case of the Bhanwari Devi and then they filed petitions before Supreme Court on the issue of sexual harassment at workplace. On 1997, August 13, Supreme Court issued guidelines, that defined sexual harassment and put ownership on the employers as well as the responsible persons and instructed to provide safe working conditions for women at the working locations. They are famously called Vishaka guidelines. So you can remember this case, Vishaka versus state of Rajasthan, right? Triple talaq case, right? Triple talaq, it became unconstitutional. They will say talaq, 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 and then women will be divorced, right? This is very archaic law. Then in this case, Supreme Court told this is unconstitutional under Sarabana versus Union of India and ORS. Supreme Court by majority 3.2 told triple talaq is arbitrary and then it is marital. This violates Article 14 of the Constitution of India. So they told triple talaq is unconstitutional from gender justice point of view, right? Another area where Sabarimala temple case, even Indian Young Lawyers Association versus State of Kerala. Sabarimala temple, it is a Hindu pilgrimage center in Kerala. Female devotees, even between the age group 10 to 50 years, they denied entry on the basis of certain, custom and usage. A constitution bench led by Deepak Mishra overruled Kerala High Court's 27-year-old decision, and he upheld that restriction on entry of the women into the temple. Quote said, one side we pray as women as a devout goddesses, and other side we don't allow women into the temple. It is a violation of the fundamental rights. So court allowed, entry of females into Sabarimala temple. So this is one important case from gender justice point of view. Even section 497 of the Indian Penal Code in Joseph Sain versus Union of India case, right? Supreme Court struck down this 497 of IPC and it criminalized, adultery. Adultery was removed. Why? Because adultery means suppose say husband and wife are there, husband and wife, some third person come, male. So this male will have relation with wife and then husband may not be knowing. This is called adultery, right? This was earlier criminal activity because in India, marriage is a integrated function and then we should respect the marriage institution. But court told wife is not slave of husband. Husband is not master. Wife is not slave. She has a fundamental right. She can decide whatever she wants. So even they struck down this adultery and Joseph Shine versus Union of India. This case is very, very important, right? Even Article 356, like imposition of president rule in state. In SR Bombay versus Union of India, right? Supreme Court gone through the misuse of Article 356 and then it imposed of president rule in several states. Supreme Court told, judicial review will involve 3 questions basically. Whenever this, Article 356 we imposed, judiciary will involve like is there any material behind the proclamation, was there any real genuine reasons were there, was the material relevant, any malified use of power. So see, because just to quote government, central government want to state government to crumble, right? Who will recommend president rule in India? Governor, right? Governor tells president that state machinery completely failed. Then president what he will do? He will act on the aid and advice of home, prime minister and council of minister. So council of minister tells Suppose say the state in which governor is there, this is opposition, central government is a ruling government. So now ruling government in central do not want state government to say there are many such political issues happen. We need to go about politics. Even governor is a issue also highly contentious. We discussed several times about this article, right? So this is SR Bombay versus Union of India. So Supreme Court told we will visit the case and then we'll understand the things what is happening there, right? Next article, it is about election reform. Nota case came. So earlier we will go to the polling booth, we'll find many candidates like this. There you will find hand symbol, sometimes you will find cycle symbol, somewhere you will find elephant symbol, somewhere you will find lotus symbol. So all this like you cast the party based on your like manifesto, whatever you have read, even political values. Some people do not like everyone. So for them, this they brought the nota. And even our election also sometimes independent candidates won't get those many votes that were casted to like nota also. None of the above. Nota means nota button came subsequently in election reforms. Right to not to vote, like nota case. Basically this is constitutional democracy. Even election reforms, Lily Thomas versus Union of India, those person who are convicted, they cannot have 3 month time period to appeal for this conviction, and this is considered as a violation of the constitution. This Supreme Court told under the PIL. Even court told that members of the parliament, legislative council or legislative assembly, those convicted of crimes and they are awarded a minimum sentence of 2 year imprisonment would cease to be members of the house. They cannot be members of the house from the date of the sentencing, basically. So this is about Lily Thomas versus Union of India case. There are three cases with respect to judiciary, right? Four cases basically. First judicial case, second judicial case, third judicial case, fourth judicial case. Right? Who will appoint the judiciary? Right? President appoints them. President acts on the aid and advice of Council of Minister and Prime Minister. Right? Council of Minister, Prime Minister. So judiciary earlier controlled by ruling party. So if their decisions come in favor, suppose say it may not be true, but if their decisions comes in their favor, so they will appoint the judiciary whom they like. So in this case, like to appointing judiciary, right? They will consult the Chief Justice of India and even President also. But in this first case, they told in case of the disagreement between Chief Justice of India whether to appoint this person or not, so President of India's opinion matters finally. That's what the first judiciary case. Then came second judicial system, and then they brought this collegium system also. What is this collegium system? We'll discuss. Supreme Court, advocates on record association versus Union of India. You can see famously second judges case. They brought this collegium system. Collegium system will include, Chief Justice of India plus two senior most judges, right? These two senior most judges and the president will appoint them. But in this case, Supreme Court told that opinion of the Chief Justice of India is final. It is binding on the president to follow. There is no consultation. He should follow whatever the recommendation given by collegium system, right? He should follow. He means president, he or she, sorry. In third judge case, they even strengthened this collegium system. Earlier, Chief Justice of India, two senior most judges were there. Now, four senior most judges. So these people, these senior judges and Chief Justice of India recommend people. So these people go to president. President should allow this, should appoint them like as soon as they decide Chief Justice of India, four senior most judges. So they told like, and subsequently fourth judges came National Judicial Appointment Commission under 99th Constitutional Amendment Act, right? National Judicial Appointment Commission, it is basically to appoint the judiciary. They told this consists of the Chief Justice of India, two senior judges, one law minister, and two eminent personality appointed by Prime Minister and Leader of Opposition and Chief Justice of India. Basically, they will constitute as a bench, and then they will appoint the judges to court. Then Supreme Court in 2014 they struck down this National Judicial Appointment Commission because this is unconstitutional, null and void. It violates the judicial values. It was completely struck down. The next article is about MC Mehta versus Union of India. This is about the environmental protection, right? Earlier, William gas leak, Supreme Court strict liability was ensured on this, Ryland Fletcher case. Basically, this is about those hazardous industries. Hazardous industries, whatever they're there. So the court held that industries engaged in hazardous activity, they should hold the absolute liability. They should have the absolute liability in this case. So compensation must be like those who are affected by hazardous industry, compensation must be in proportionate to hazardousness, and then those hazardous industry must be hold the liability. This is about the environmental protection. MC Mehta versus Union of India. Even in social justice case also, 50% threshold on the reservation, even creamy layer also capped. Indrasani versus Union of India case. This is very important case. Under Article 16 basically grants employment reservations to the people. So Supreme Court told Article 16(4) can be identified on the basis of caste, not on the economic conditions, right? It uphold 27% reservation to the OBCs, and then 50% cap on reservation is also included in this, judgment. So subsequently, economically weaker section judgment also came. We will discuss later all those things. Thank you very much for the discussion.